Okay, everybody, we're going to get started now with our 10:35 panel, Creative Approaches to Fighting Climate Change. My name is Christopher Berry. I work at the Animal Legal Defense Fund, and I'll be moderating the panel. And people might wonder why we're talking about climate change at an animal law conference, and superficially it seems like an environmental issue. However, the environment affects everybody in the environment, and that includes countless of wild animals who will suffer as the climate changes or as the world is polluted. Additionally, one of the major contributors of climate change and environmental pollution generally is animal agriculture. So climate change is very much also an animal law issue and something that we all should be thinking about. And to that end, we have a wonderful panel today talking about approaches that we can take in animal law in order to address climate change. And in the order of presenters today, first, Daniel Waltz, who is a staff attorney at the Animal Legal Defense Fund. And when he's not in the trenches with me on our California puppy laundering lawsuit and the latest discovery shenanigans going on there, or deposing someone in one of our many roadside zoo cases, Daniel Waltz is one of our administrative litigation gurus. And I think one of his best attributes is just how tenacious he is. Whenever a defendant or even a court does something that is unfair or unjust, even if we don't have to do anything about it, Danny will stay up until midnight drafting some kind of motion or response to correct the injustice, which some people might think is over the top, but actually just makes me feel lazy when I compare myself to him. And second, Jessica Blome. She is a senior counsel at Greenfire Law, which specializes in providing strategic legal and litigation advice to many clients, including the Animal Legal Defense Fund. In a previous life, she also worked at the Animal Legal Defense Fund and sued Cricket Hollow Zoo, a roadside zoo in Iowa, under the Endangered Species Act, which became, as a result of her litigation and trial, for the first time a court applied the Endangered Species Act to the husbandry of animals in captivity, and she obtained a possession ban that the facility couldn't have endangered animals, which was upheld by the 8th Circuit Court of Appeal. And for the non-endangered animals, in fact, has been litigating with us and Amanda Howell, also at the Animal Legal Defense Fund, under a public nuisance theory for animal cruelty. And that case actually just went to trial, and Jessica flew from trial in that case to this conference. So she'll be putting those great litigation skills and has been putting them to use in our lawsuit, Animal Legal Defense Fund versus the United States of America, which is argues that there's a constitutional right to wilderness based on our fundamental right to autonomy. And she'll be talking about that case. And then last, Professor Randall Abate at Monmouth University in the Department of Political Science and Sociology, and the Rechnitz family Endowed Chair in Marine and Environmental Law and Policy. Professor Abate has gotten about half of the Animal Legal Defense Fund lawyers to contribute to his many publications, including What Can Animal Law Learn from the Environmental Law, and has a book that just came out, Climate Change and the Voiceless, Protecting Future Generations, Wildlife and Natural Resources, and he will be talking about the Green New Deal and animal agriculture. So help me welcome our speakers today with a round of applause.
Thanks, Chris. I'm thrilled to be on a panel with you and Jessica and Randy, three lawyers who are experts at the overlap of environmental law and animal law. Since the 1990s, the Environmental Protection Agency has prepared an annual comprehensive survey of greenhouse gases and their greenhouse gas emissions from man-made sources in the United States. I'm showing a chart from the 2019 EPA report calculating emissions. And it's hard to read this, but what it shows is the most current figures from EPA, which I just heard as we were chatting in the back, is probably an underestimate. Shows that 8.4% of greenhouse gas emissions in the United States come from agriculture, and over half of those are from either enteric fermentation, which is cow burps, or manure management, such as lagoons of waste in concentrated animal feeding operations, or CAFOs. And methane is a particularly powerful greenhouse gas. I don't have that highlighted here, or the data here, but one data set in this report is that total methane emissions have actually dropped from 1990 to 2017. But the decline has come from reductions in certain industries such as landfills, natural gas, or coal mining. Enteric fermentation and manure management at CAFOs have actually both significantly increased. So while in many industries we're seeing climate emissions, or methane emissions in particular, dropping, the emissions from factory farms are going the other way, the wrong way. I'm going to talk about our case that seeks to confront these emissions, but I first want to set the stage with some good old federal government in action. My favorite. The federal government has long known that the animal agriculture industry emits a wide variety of air pollutants, including long-lived greenhouse gases like methane and nitrous oxide. And the story of how the government has acted or not acted on that knowledge is the story of an iron triangle. I'm not sure if folks are familiar with the term iron triangle, but as I understand it, it's an unholy alliance between Congress, regulatory agencies, and the industries that the agencies and Congress are supposed to regulate. And once they align, industry is effectively immune from regulation, and it's hard to break through that alliance, that iron triangle alliance. So one example of the iron triangle begins in the 1990s. Sierra Club and its allies brought several cases against big CAFOs for their failure to report their hazardous air emissions. These succeeded, causing CAFOs to actually report those emissions to local communities and first responders. They were clever cases because they used general environmental laws that had previously been applied to other major polluters like chemical factories, and applied them to industrial animal agriculture. They were clever, but they backfired. The Bush EPA responded to the lawsuits by creating the Air Compliance Agreement, where industry forces persuaded EPA that it was just too difficult to measure air pollution emissions from factory farms. And so in the agreement, EPA promised not to bring any enforcement actions against CAFOs or against factory farms under 3 different federal air quality statutes: the Superfund Law, which requires reporting, the Emergency Planning and Community Right to Know Act, which requires reporting of emissions, and the Clean Air Act. And in exchange for this non-enforcement promise, the factory farm industry threw a few bucks at EPA so that EPA could study how CAFOs cause hazardous air pollution and climate change, and in what quantity. That was supposed to have been completed a decade ago, but as folks here might expect, EPA hasn't even issued a draft analysis of how CAFOs cause air pollution. And using this delay in research and claimed scientific uncertainty about air emissions, the Trump administration has declined to designate factory farms as sources worthy of regulation under the Clean Air Act. Another more recent successful lawsuit led to a second story about the factory farm iron triangle. As I mentioned, Superfund Law and EPCRA, the Emergency Planning and Community Right to Know Act, require facilities to report their air emissions once those emissions are above a certain threshold. And in 2008, EPA administratively exempted factory farms from having to report those emissions. A coalition of groups, animal groups, environmental groups, community groups, challenged that administrative exemption. And in 2017, the DC Circuit found that that exemption was arbitrary and capricious. They said that, the panel said that a refrigerator plant that emits, say, ammonia over a certain threshold has to report its emissions. And so should a factory farm. It doesn't matter to the neighboring community where the ammonia is coming from. If it's this quantity and it has this effect, reporting is required. But like the Sierra Club cases, the opinion sort of seemed like it was a breath of fresh air to communities and to advocates, but it ended up leading to toxic deregulation or sort of carve-outs. Congress enacted the Fair Agricultural Reporting Method Act, the FARM Act, which legislatively repealed the DC Circuit decision for Superfund reporting obligations. And though the law left in place the air emissions reporting obligations under the Emergency Planning and Community Right to Know Act, the Trump administration immediately created a rule that exempted reporting there. So we're back to square one, where no factory farms have to report their air emissions, their air pollution, no matter how hazardous it is, no matter whether they're greenhouse gas emissions or in what quantity, even though in the early 2000s they were under that obligation. So this slide is really a long-winded way of saying that while there are laws that are on the books concerning air pollution, and they would be natural vehicles for regulating air emissions from factory farms, Congress, the regulating agencies, and industry have all worked together to carve out a broad exemption for animal agriculture. I mentioned, though, that the Sierra Club cases were clever cases because they used general laws. And one general environmental law that, to my knowledge, has seen limited use in the factory farm context is, or with regard to greenhouse gas emissions from factory farms, is the National Environmental Policy Act, or NEPA. Advocates have actually started to find success in using NEPA to challenge other industries that contribute to climate change, which can chart a path for applying NEPA to factory farms. So here's how NEPA works. It requires federal agency actions that have significant effects on the human environment. When those actions occur, the agency must first prepare an environmental impact statement, which we often refer to as the environmental review of the action. And while this requirement is strictly procedural and doesn't mandate that agencies come to some sort of environmentally friendly outcome, it can lead to change on the ground in a number of ways. It requires that agencies consider the alternatives to their action and the environmental effects of those alternatives, which can force action towards an environmentally friendly outcome, if so desired. It allows advocates to delay federal projects and shine a light on their environmental impacts, which can allow the public to step in and call for the agency to stop the action, or for legislatures to stop the action, or simply just to rack up costs and cause the planned project to die through delay, through death by 1,000 cuts. It also requires agencies to hire scientists and other environmental researchers to really understand the environmental impacts of the actions. And so that can help green the agency by adding staff that will have a shift decision-making in a more environmentally friendly direction. Courts have been slow to require NEPA environmental review for federal agency projects that contribute to climate change. And I think one of the reasons courts have been slow to do this is because a key defense that the government often uses is that greenhouse gas emissions are complicated and speculative and often hard to quantify. And so environmental review in that situation would not have much value. But I'm highlighting a recent case from the DC Circuit. This is Wild Earth Guardians v. Zinke, where, the DC Federal District Court in the District of Columbia, where a judge found that oil and gas leases actually could be quantified, or could have greenhouse gas effects, greenhouse gas emissions that could be quantified and forecasted, and agencies could forecast the environmental effects of those greenhouse gases. So NEPA is starting to gain teeth in the climate change context. And if really the ability to quantify greenhouse gas emissions is enough to trigger environmental review under NEPA, then there's no reason that NEPA shouldn't apply to factory farms. I'm showing here, the top is a worksheet for calculating emissions of methane gas from manure lagoons. And then the lower part here is a chart showing methane emissions, calculated methane emissions from pig farms in Iowa that are the size 1,250 pigs. What's interesting about this, so it's a little fuzzy, but it shows that a 1,250 pig factory farm in Iowa emits just under 1 metric ton of methane each month. Both of these are actually from the Environmental Protection Agency. So in future cases, you really can't see the federal government. They shouldn't be heard to say it's impossible to measure greenhouse gas emissions from factory farms. We have a chart from 1999 where they're doing just that. And a recent case from Minnesota State Court shows that NEPA might be a viable way to require federal agencies to consider the climate change impacts of supporting factory farms. Minnesota has a state version of NEPA that operates in a very similar way to federal NEPA. And a couple of weeks ago, a court of appeals in Minnesota found that the Minnesota State Environmental Agency erred when it permitted a large dairy factory farm without considering the environmental or the climate change effects of the dairy. And because it didn't consider the climate change impacts of the dairy, the court vacated or revoked the agency's permit, which meant that the dairy can't begin operating until the Minnesota State Agency goes back and performs an environmental review that considers climate change. And so Minnesota shows that NEPA may be a path for forcing agencies to reckon with the climate impacts of supporting the factory farm industry every time they facilitate the growth or the creation of or the expansion of a CAFO. And that leads me to a lawsuit that ALDF and a coalition of groups have filed this year to ensure that NEPA helps regulate the climate effects of factory farms. So for some background, the USDA's Farm Service Agency provides funding support for agricultural producers in the form of direct loans or guaranteed loans that support guaranteeing loans from private lenders. One subset of these loans are to the factory farm industry. So that means that the Farm Service Agency is spending taxpayer dollars to fund meat and dairy producers and really acting as the but-for cause of new or expanded factory farms. For at least 2 decades, the Farm Service Agency actually performed a NEPA review before it issued these loans. It was minimal environmental review, but it was environmental review. But in 2016, just before the presidential election, the Obama administration offered a giveaway to animal agriculture. It categorically excluded or exempted medium-sized CAFOs. So these are CAFOs that house up to as many as 700 dairy cows or 2,500 pigs, and they have numbers for each species. It exempted those CAFOs from any NEPA review whatsoever. And if you remember, a factory farm with 1,250 pigs emits just under 1 metric ton of methane a month. So double that for medium CAFOs. As a result, even though the federal government is causing these CAFOs to come into existence, it's not considering the environmental impacts of them. It's not considering how they contribute to climate change. It's not considering how they pollute nearby ground and surface water or increase the risk of increase the likelihood of antibiotic resistance or the risk of spread of disease. And also because NEPA is not kicking in, neither do its public notice requirements kick in. So communities aren't receiving notice that these waste-producing factories are moving in right next door to where they're living. And the only reason the Farm Service Agency gave for creating this categorical exclusion or exemption is it would increase the burdens or the costs on industry. But that's not a reason for making any decision under NEPA, which is a statute. It's called the National Environmental Policy Act. It's just focused on the environmental impacts of agency action. It's not the National Regulatory or Industry Protection Act. I'm not very good at acronyms. On behalf of animal advocacy groups like ALDF and environmental groups and rural community groups, we brought suit. We had a very simple argument. NEPA says agencies have to perform environmental review when they undertake actions that have individually or cumulatively have a significant impact on the environment. And medium-sized CAFOs, both on their own and together, often they're bundled together in watersheds and or around slaughterhouses, they have effects on the environment. So therefore, the Farm Service Agency violated the law when it created this carve-out under NEPA. And what's fun about this case, actually, maybe fun's not the right word because the carve-out is somewhat horrifying, but from a movement lawyer's perspective, what's interesting about this case is that it requires us to demonstrate that factory farms generally have significant impacts on the environment. And this is a very broad sort of standard that we are trying to meet. So we get to highlight all the variety of harms, environmental and public health harms that CAFOs cause. And one key section of our brief is that CAFOs contribute to climate change through their emissions of greenhouse gases like methane and nitrous oxide. So if we're successful, in the future, the Farm Service Agency would have to do NEPA environmental review that quantifies the amount of greenhouse gas emissions and pollution and other air pollution from CAFOs. And that will show that agencies can estimate their emissions, which could then lead us back to the air compliance agreement and show that if they know how to quantify the emissions and what the effects will be, there's no justification for being unable to have other environmental law obligations like under the Clean Air Act, the Superfund law, and the Environmental Emergency Planning and Community Right to Know Act. As I mentioned, this case provides opportunities to catalog the variety of negative effects of factory farms. And I want to just highlight two that are showing up in this case. The first is environmental justice. The disproportionate environmental and public health effects felt by communities of color or by low-income communities is an environmental effect that should be considered under NEPA. And so we argue then that Farm Service Agency erred when it exempted CAFOs from NEPA review because factory farms often sprout up in and cause harms to environmental justice communities. And this example here is from the San Joaquin Valley, which is thoroughly polluted in its air and water resources, and is also regularly suffers from droughts. The yellow dot here on the lower photograph is a medium-sized dairy CAFO that was funded by the Farm Service Agency in 2016. And it's across the field. Below it is a Native American reservation. Up here is a GIS mapping tool from EPA for the same area, and it shows demographic data. And what it shows is that the demographics for this area are over 50% of the population is a low-income community, and over 80% is a minority population. So this is an example of potentially environmental justice impact. Another opportunity here that, in this case that we're focusing on, is that animals are part of the environment. And in our brief, we've argued that factory farms cannot be exempted from NEPA because the air pollution, the water contamination, and the risk of spreading disease harms not only humans, but two different types of non-human animals. These types, the first type is the wildlife, like endangered and threatened mussels, or the Indiana bat, who inhabit the areas surrounding CAFOs. And second are the animals inside the CAFOs themselves. We talk about toxic air emissions to nearby human populations. We're concerned about ammonia and hydrogen sulfide leaving factory farms and affecting human neighbors. Just imagine what those concentrations are like inside of the CAFOs themselves. And by situating the animals and their health as part of the affected environment, as we're doing in this brief, we're working to tear down the distinction between humans and other animals within the context of NEPA. It's really just the environment includes humans, the environment includes animals. All should be considered. So you may have noticed that I've been talking about this lawsuit in the present tense. We're at the nearing the end stages of the litigation, and we're in an unusual procedural posture. So about 2 months ago, Farm Service Agency conceded that it messed up when it created the categorical exclusion. We thought we'd won. But instead of rescinding the exemption, the agency just said it was going to come up with a new justification, a better justification for why the exemption should exist, all the while keeping the exemption in place. And so in response, we initially thought we'd won, and we realized the remedy or the outcome would be the exact same, the situation we're in. So we decided to go on the attack and file a motion for summary judgment. And we argued that even if the agency went back to the drawing board, it would be impossible for it to justify the exemption of medium-sized CAFOs, because those facilities, individually and cumulatively, have significant effects on the environment. Environmental justice perspective, effect on the animals, and then also climate change. And so by moving for summary judgment, we hope to get a precedential decision that will strike a blow at industrial animal agriculture and its hazardous emissions and greenhouse gas emissions, and really slow the flow of federal government funding of factory farms. Thanks, and look forward to questions.
Good morning. My name is Jessica Blome. I'm an attorney with Greenfire Law, just to remind you from Chris's very kind introduction. I'd like to begin with a poem that I think really helps kind of contextualize the situation we're in light of what we just heard from Danny, and the reason why immediate action is necessary in order to avert the climate crisis. May we raise children who love the unloved things, the dandelion, the worms, and spiderlings. Children who sense the rose needs the thorn and run into rain-swept days in the same way they run toward the sun. And when they're grown and someone has to speak for those who have no voice, may they draw upon that wilder bond, those days of tending tender things, and be the ones. And that's Wilder Child by Nicolette Sauter. And I wanted to begin the last panel of this wonderful animal law conference with this poem because I think it reflects a natural ethos we inherently accept at the beginning of life. And as we age, we are assimilated into a society, both culturally and socially, that has long ago replaced that natural ethos with an ethos of consumption. Long before we could formulate thought or opinion about how we wanted to live, breathe, and experience the world. Upon full assimilation, we as adults might justify the exploitation of nature, including the living things and creatures we once held dear to our hearts. And instead of marveling at dandelions, we ask whether we should grow them for sale as a superfood. We debate whether we should protect certain species from extinction or eradicate them to exportation. Instead of trying to understand the importance of worms and spiderlings in a functioning, thriving ecosystem, we kill them with pesticides so they don't eat our food. Rather than protect the spirit of wilderness in wild places, we innovate ways to extract resources from wild places for corporate profit. Last October, the Animal Legal Defense Fund decided to do something about that. We joined a national indigenous women's organization called Ceding Sovereignty to sue the United States government for failing through the actions and inactions, a lot of which was just highlighted by Danny, to protect our right to wilderness, and their failure to protect our right to wilderness as the last meaningful expression of our due process right to be let alone, free from government interference in the wild. Let me take a quick poll. How many of you recreate in wilderness? A lot. How many of you need that experience in wilderness in order to feel most like yourself? And how many of you feel so connected to wildlife you observe in wilderness that without it, your sense of self would suffer? You have a lot in common with our plaintiffs. Our plaintiffs include scientists, nature enthusiasts, and wildlife advocates who are no longer able to safely conduct their research or interact with nature due to the catastrophic impacts of climate change. They fear increasingly severe and frequent wildfires, mudslides, and avalanches. They cannot meaningfully connect with nature and animals due to disappearing snowpack and edible plants, and they are victims of flash flooding, all of which have been made worse due to the damage caused by climate change. And I think I'd be remiss if I didn't note that today, on this very day, even the executive director of the Animal Legal Defense Fund is under evacuation, mandatory evacuation from his home due to the catastrophic impacts of wildfires in Sonoma County. Through this lawsuit, the Animal Legal Defense Fund alleges that the government, through the affirmative subsidization of consumptive industries including animal agriculture, fossil fuel development, and deforestation on America's public lands, has worsened the climate crisis, which has in turn caused the irreversible degradation of wilderness that our plaintiffs need in order to meaningfully exercise those rights to liberty and autonomy. In other words, without nature, the right to be let alone, which is guaranteed by our First, Fifth, and Ninth Amendments to the Constitution, is an empty promise. It's meaningless. Now, I mentioned that we sued the federal government. We sued the United States through the Departments of Agriculture, Interior, and Defense, the Defense as the largest landowner in the United States, separate from the Interior BLM. We also sued the United States Environmental Protection Agency because there is no remedy without the Environmental Protection Agency. We filed that lawsuit here in Oregon, in the Eugene Division. And because we're in Portland and in Oregon, among fellow activists and allies, many of you have also probably heard of the youth case, where our Children's Trust and Earth Guardians sued the United States federal government on behalf of dozens of youth who have now grown up, also alleging a constitutional depredation of rights as a result of climate change. And I'll talk about the differences between that case and our case in a moment. But first, let's talk about what remedy we seek. We seek a radical remedy, don't get me wrong. We seek the elimination of the subsidization support and federal support for private industries in fossil fuel development, both on federal lands and off. We seek an end to subsidization of animal agriculture, both in the use of federal lands for grazing and in federal support for the crops that are necessary to feed animals that are housed in small factory farms that then enterically fermentate and cause climate change. And we seek an end to commercial logging of old growth forests on federal public lands. So our remedy is very focused and direct and would have a lasting impact to avert the climate crisis. Now let's talk about the youth case, the Juliana case. The youth case has been remarkably successful in its litigation. It made it to the point where on the eve of trial, the United States federal government filed an emergency motion to have the denial of summary judgment by the district court in Oregon certified for appeal to the Ninth Circuit. The district court in Oregon denied that emergency notification, and the government took their case to the Supreme Court through an extraordinary effort on their part, and the Supreme Court, having newly seated Justice Kavanaugh decided to intervene in, an unprecedented way to direct the Ninth Circuit and to direct the district court to certify that decision and then direct the Ninth Circuit to consider certain factors when it evaluates the summary judgment motion. That case is now fully briefed before the Ninth Circuit, and we await very impatiently the Ninth Circuit's decision. And that's for very important reasons, because the youth case is, without the success of the youth case, this case is not possible. So let's first talk about the differences and then talk about the similarities between the youth case and our case. The youth case allege, in addition to their substantive right to due process, that the government has violated the children's 14th Amendment right to equal protection under the law, because the government, through its actions and inactions, has prioritized the interest of current generations over the interest of future generations in failing to avert the climate crisis. The youth also argue that the federal government, through its affirmative actions to subsidize fossil fuels alone, has violated their due process right to a livable future. So they're looking for a baseline of a sustainable atmosphere for which to assess whether or not their right to a livable future has been violated. Third, the youth argue that the government has failed to protect the atmosphere as a resource held in public trust by the federal government for the benefit of all Americans. And finally, the remedy they seek is a structural injunction which would require the government to work with its various agencies in order to develop a remedial action plan to avert the climate crisis, again with an eye toward protection of a sustainable atmosphere for the benefit of the human plaintiffs. Our case, according to the District Court of Oregon, is more radical. We allege that the federal government has failed to protect the non-human world, not the atmosphere. And in so doing, we ask the court to recognize wilderness as the baseline for a meaningful expression of our right to be let alone. Wilderness as a baseline is protective of all creatures, not just humans. And that's not an accident. We're animal rights attorneys. Humans could live in a sustainable atmosphere that may not protect dandelions and worms, or elephants and bears. And we seek absolute protection of those intact ecosystems for the benefit of all humans and non-humans alike. Now, what's the status of our case? As I mentioned, the district court considered that remedy, our remedy, and our right to be more radical than that of the Juliana case, the youth case, and they dismissed it on the day after the government filed their reply brief. So I think they had an idea about what they wanted to do. They dismissed it for 3 reasons. First, because our judge believes that no single person can possibly allege a concrete and particularized injury caused by climate change under Article 3 of the United States Constitution, because climate change causes injury to all of us, and it is an injury shared by all of us. Now, the same district court, through a different judge in the Juliana case, made a completely different decision and upheld their standing to file that case. So in one court right now, it's possible for one plaintiff to have an injury, but according to another court, it's not possible. For that reason, the outcome in the Juliana case is critical to the success of our case. Second, the district court found that in remedying the catastrophic impacts of climate change, the court would have to wrestle with a political question that was more appropriate for the legislature, more appropriate for Congress. For the reasons that we've articulated, the Juliana plaintiffs were successful with their separate judge in the same district in arguing that it's not a political question, that the judicial branch has a duty and a responsibility to react to congressional participation in the Iron Triangle that Danny discussed earlier. So again, the Juliana case is critical to whether we can succeed, because if the Ninth Circuit decides it's not a political question, we get to go forward. Third, the district court decided the merits of our case on the motion to dismiss in a couple of paragraphs, finding that there's no constitutional right to a certain environment, and therefore the district court could not mete out the remedy that we sought. Indeed, the district court recognized our remedy was more protective and therefore more radical than anything that had been requested of a judicial branch before. So the Juliana case, as I mentioned, is certainly currently before the Ninth Circuit, and we're working with the Ninth Circuit Mediation Office and the government to informally delay our briefing until the Juliana case has been decided. We hope that the Ninth Circuit comes out on the side of the Juliana case, and we obviously all, as a movement and as a community, root for their success and for their opportunity to go to trial and expose the government for what it has done on climate change. And I just conclude by saying that in doing this, the Animal Legal Defense Fund, Ceding Sovereignty, its members, and everyone in this room has identified themselves as the ones who will protect the wilder places, the wild animals in the non-human world, the animals who are being just treated in immensely terrible ways on factory farms and on federal public lands where they're left to starve and not checked on, where animals are trapped on public lands. All of these things that we're doing renders us the people with the capability and the will to try and do something to remember and protect our shared connection with nature. Thank you.
Well, it's wonderful to be here, and part of this panel. It's always inspiring to be able to share the stage with such outstanding attorneys doing wonderful work on behalf of animals. Always a pleasure to be here at the Animal Law Conference. I am grateful to the organizers for the invitation to speak on this panel. As an academic, my remarks may come as a surprise to you, will be more conceptual, and that's kind of the space I live in. I'm very excited about thinking about these issues, about strategically how to advance the protection of both the environment and animals, and in my most recent work, future generations' interests as well, as similarly vulnerable and similarly compromised by the climate change crisis. So picking up on the themes that you've heard from Danny and Jessica, the factory farming in one sense is something I'm going to be focusing on, picking up on Danny's remarks, and then also this sense of bold and creative efforts to address how to more effectively address the climate change crisis within the context of animal protection. So the focus will be the Green New Deal, and I'm going to tell you more about that. And the focus will also be on the common enemy for both animal law and environmental law, namely factory farming. So I want to start with some themes that, if you take away nothing else, I want you to take away these points about what unites the three presentations on this panel. And the first is the value of creativity in this space. One thing that just inspires me every day to continue to do what I do as a teacher and scholar and a collaborator with attorneys and folks outside the law is how effective these creative efforts have been in achieving victories in environmental and animal law cases, how we need great lawyers like the ones up on stage and throughout this conference to really make change in the law. And second is Jessica made reference to radical in terms of what's being requested, and that is a theme that resonates for me. Both bold and radical efforts to seek change are more important than ever now. The clock is ticking quite loudly in our ears in trying to address these changes. And the third is understanding the common enemies, identifying and targeting common enemies. So Danny referred to the iron triangle, and that is certainly a common enemy for both environmental and animal law efforts, but certainly in the context of this panel, factory farms as the common enemy, and one that can be hopefully reeled in our effort to address climate change and also to protect animals. So just a brief roadmap of what I'd like to address here in the likely event that I run out of time. I've done a lot of thinking about what makes bad things continue in our society, and if we think about climate change as a bad thing that we've created, and we know we've created it, we know it's harmful, and it continues, particularly in the US. So I want to give you a context for thinking about that, and then how important it is to think strategically about how we get past that stuck in the mud place we are in with respect to regulating climate change. And then I want to introduce you to the Green New Deal as a creative and bold effort to craft a response to that status quo that we're currently struggling with. And also draw your attention to how just within the past few years there's this growing undercurrent of awareness about how we need to act more creatively and boldly and where we need to focus our efforts. And that's a source of encouragement for me in thinking about these issues. And then certainly how just the value of dialogue and how the dialogue on these issues can force change in our social culture, and that in turn can ultimately influence the legal framework that is governing these issues. And I'll give you some examples of that from both environmental and animal law. And then just to conclude with some specific recommendations about how to incorporate animal agriculture into the Green New Deal, or what it might ultimately become if it becomes legislation in the future to more effectively address animal agriculture. So it's a win-win theme. The idea is we have to address climate change as an environmental issue, and we also have to improve the lives of animals as we're trying to address the climate change issue, and this is one way to achieve both efforts with one stone, so to speak. So just thinking about cultural realities, the status quo of climate change regulation avoidance, there's a false narrative that we just have to get past, which is regulating climate change is catastrophic for the economy. The rest of the developed world understands that that's not true, but somehow as Americans we don't. And that false narrative needs to be changed. And I think ultimately we were able to overcome that false narrative in our first wave of environmental regulation. Ultimately, regulating the environment took hold in the 70s, and part of that change in thinking was environmental compliance is a good thing, and it's economically beneficial to be in compliance with these environmental laws, that it was ultimately a connection between environmental and economic objectives. We're not there yet with climate change, and we need to get there soon. And then we've also got the other reality of just partisan politics, how ridiculously oversimplified and inaccurate it is to think about, as a Democrat, you're supportive of regulation of climate change, and as a Republican, you're not. I mean, we've rarely seen such division on any kind of social, political issue in our country the way we do on climate change, and it's preventing ourselves from thinking more deeply about the issues the way we used to, when we used to be able to achieve bipartisan consensus on a lot of these things. Certainly, Representative Blumenauer provided some very encouraging examples of how there is a movement toward more bipartisan efforts to address animal protection, and those are very promising starts, but we have a massive road ahead of us with climate change. Ultimately, the thing that I've been thinking more about with climate change is that it's more a human nature issue, that even those who care about social and environmental and animal issues, there's always that challenge of getting over the hump of being stuck in the status quo. Change is threatening, change is perceived as expensive, and ultimately it's something that's difficult to mobilize the public to see that there's a better path. So, talked about the bold and creative responses. I can't stress that enough, how important that's going to be. And ultimately, the other piece of getting those bold and creative responses to stick is this idea of what is politically feasible, regardless of how ambitious and flaming liberal we are about what we want to achieve. We have to be realistic about what is politically feasible and culturally accessible with the audience we're working with in the US. And so, my compromise there is this idea of low-hanging fruit, that ultimately you're not going to be able to make the U.S. carbon neutral by tomorrow, but you certainly can start an awareness building campaign as a political effort to address things that are very harmful, and if we address very harmful things, we will see significant gains in what we're trying to regulate and not so much sacrifice, because Americans are not known for being very good about sacrificing their comfort zone. So one example I provide of that is our HFCs, and that's not something I'm going into today, but basically that was one of the most troubling examples of unintended consequences in environmental regulation. We applauded ourselves for fixing the ozone depletion problem by transitioning away from a harmful pollutant, CFCs, coming up with an alternative, HFCs, And now this monster we've created to cure the ozone problem is by far the most potent greenhouse gas that's making climate change worse than it already is. So some efforts now are being applied to that low-hanging fruit, that if we just get a handle on transitioning away from HFCs to a climate-friendly second alternative to the alternative, then we're in a better place pretty quickly. But the focus of my remarks are going to be on methane. Methane is another low-hanging fruit, significant evil in how we're trying to address climate change. It's something that's much more potent than carbon dioxide and far less ubiquitous. It's much more difficult to come up with an effective way to regulate carbon dioxide because it's everywhere. But methane, and in particular methane as it's coming from factory farms, is a very discrete target, something that we can gain consensus more readily to address effectively, and that makes it more like the ozone depletion problem. We just had one sector of the entire economy we had to fix. We had to get that CFC problem taken care of, or we were going to eliminate biological life on Earth within a century. So we responded. And that's one thing that is also encouraging as I think more about these issues. Crisis brings out the best in our legal responses. History is showing us that. And so now that climate change is more of that urgent crisis and not something that will happen someday and we don't need to care about it today, I'm hopeful that we're going to have a more effective response the way we did with ozone depletion to really tackle climate change more effectively and creatively and immediately now than we were thinking about it just a few years ago. So the Green New Deal is talk. I want to emphasize that. This is a resolution. This is not proposed legislation. But it's not cheap talk. So I want to stress how important it is to have the Green New Deal on the table as a reference point for the climate dialogue that is so overdue in our country. So one thing that's incredibly valuable about the Green New Deal is the fact that it embraces climate change as this tripartite threat. It's not just an environmental issue. It is an economic issue, and it is a social issue. And so that, to me, is one of the greatest successes of how the Green New Deal is drafted, that it conveys climate change as that three-part reality. And those that are spinning the false narrative are referring to climate change as just an environmental problem. We don't have to cripple our economy to think about it. So, two things about it in terms of what's valuable about it being just words and not actually proposed legislation right now. The idea of it being a vision, and that I can't stress enough how important it is to be bold and ambitious with the vision. And we have examples of that throughout our legal systems in the US. I'll give you two quick examples from environmental law, the Clean Water Act and the Endangered Species Act. Remarkably bold language in each. We're going to clean up the nation's waters by 1985. Sure we are. We didn't, but the fact that we were being so ambitious about taking that water pollution problem that seriously, that defined our objectives, that even if we don't get there, we care about it enough to say we're going to try to get there. Likewise, the Endangered Species Act. Halt and reverse the trend toward species extinction at whatever the cost. We haven't always lived up to that declaration either in the objective section of the Act, but the fact that we wanted to live up to that objective is very important. And of course, the Declaration of Independence as another reference. It's not our Constitution, but it defines the way we roll, the way we think about ourselves in a democracy and how we project our goals as citizens. So that's one piece, and then the idea of dialogue. The fact that 3 decades worth of no dialogue on climate change ultimately has stopped with the Green New Deal, that it has inspired this massive dialogue nationwide. I would have never been able to predict 2 years ago that this year we'd have an entire evening of climate change candidate discussions. That was even too long for me to listen to, and I'm just living and breathing this stuff. So this has changed radically. When you look at 2016 to 2020, climate change was not on the radar screen about how to gain the White House in 2016. Now it's everything about what candidates need to be positioning themselves for if they want to get the White House. So that to me is very powerful, that just the discourse that the Green New Deal has inspired, it has created a new left of the right, and the right being the wrong, of course. The right is do nothing, continue to do nothing, and now the left is way over to the left, which is we're going to go carbon neutral by 2030. How about that? And so that's created a new middle ground that I think we might end up achieving, which used to be radical, which is some kind of carbon tax. You know, that used to be, oh, you crazy commie, you want a carbon tax. Well, now a carbon tax looks conservative compared to what the Green New Deal is proposing, and maybe there's some hope for bipartisan victory there. And of course, what's most encouraging related to this context is climate change and animal ag connections are a part of this growing awareness, a part of this growing dialogue. And that, to me, is very encouraging as a potential way of making effective responses. So this is happening at all levels of governance and all levels of dialogue about climate change right now. So the IPCC, these are the folks we turn to. It's like, are we going to die yet? And they are giving us this mandate. They've referenced a 12-year window of meaningful global action for climate mitigation. Otherwise, we're just going to be bracing for impacts. And as part of that dialogue of gloom and doom, they've also wisely drawn our attention to our food system is broken. This is why we have such a crisis with climate change. It is about how we grow our food waste, and ultimately our meat-heavy diets are a huge driver of why climate change is as bad as it is. So the fact that they are drawing our attention to that is very significant. And then we've got, for the first time ever, climate change hearings, congressional hearings on the connection between climate change and ag. That's happening in 2019. One of the authors in the second edition of my book is on that committee, the House Select Committee on the Climate Change Crisis, and they are having hearings about this very issue, about identifying the challenges of agriculture's contribution to climate change and what we can do about it. And then we've got, of course, the presidential candidates, not just talking about climate change in general, but agriculture is a piece of what their message is about how we need to address climate change. And then you've got state governors, like the Colorado governor, talking about encouraging meatless production as a piece of what we think about with animal ag. And you wouldn't have thought that was coming a few years ago either. So radical change is happening before our eyes just this year alone. And then connecting that to the animal law world, another thing that keeps me inspired. I need lots of inspiration these days. Otherwise, you know, if I thought about climate change and nothing else, I would curl up into a corner and cry all day. So the animal law side of the equation gives me great hope as well. I mean, when I think about how much culture has changed about very harmful cultural activities with respect to animals, bringing down Ringling Brothers, bringing down SeaWorld in the span of the same year, never saw that coming. I mean, I was one of many Americans who didn't think twice about bringing his son to an aquarium show, to a circus when he was a child 20 years ago, and now that culture has changed completely. And it's through efforts, creative and bold efforts of lawyers to create those outcomes. And as Representative Urban said, it is about the local grassroots dimension of all this, how those local bullhook ordinances were driving much of what ultimately led to the demise of elephants at Ringling Brothers shows. And so, to the extent we can carve a new path for what our cultural traditions and expectations are, a lot of that is happening already from the ground up, and I'm encouraged from prior experiences with what used to be so socially acceptable is now absolute taboo. In the course of my lifetime, people smoked everywhere. Planes, restaurants, everywhere there was air, there was smoke. And now it is ultimately shamed. I don't dislike people who smoke tobacco, but I feel the sense of, I'm so sorry I'm making this choice, I can't help it. It's that sense of cultural shame that's been projected on a habit that not only harms them, but harms the public. And that's a very direct connection to what we see with other environmentally damaging activities. They damage our health, they damage the environment, they damage animals, and of course you should be thinking about factory farming. So we're already seeing in the context of the climate change crisis that other cultural forms of shaming are happening before our eyes. I was in Europe this summer, and people were looking askance at me when they understood that I was on a global book tour. And I got the kind of dirty look of, do you really need to travel to so many places to talk about these issues? And I hadn't really thought about that in the sense that I feel like my carbon offsets are kind of informing and inspiring people to do something about this global crisis, so maybe I get a pass. But it did make me think harder about it, and I'm always thinking about carbon footprint issues more locally, about transportation and where I live and what I eat, of course. I'm at this conference. But this idea about beef shaming is, I think, what's next. So much has happened in transitioning culturally in a way that could make factory farms an easier target. And I've noticed when I tell people about my food preferences, not to be holier than thou, but just it comes up in conversation. No, I'm not going to join you in that cheeseburger. Here's why. A lot of their response is starting to recognize that they're trying to, or they have moved away from something like beef, or they understand why it's important, but they just love the taste. And that's okay, but ultimately that could be the next social movement similar to tobacco that ultimately percolates up to, here's why we need to regulate this, it's not acceptable anymore. So ultimately, there are very incremental ways we can address agriculture that don't involve animals, and that is, at a bare minimum, we need to manage methane better on factory farms. Danny made reference to the manure lagoons, as wonderful an image as that is, it's also catastrophically bad for the environment. And so, better management of methane on site and encouraging, incentivizing farmers to be the stewards they want to be, but often can't afford to be in managing those challenges for both climate change and for animals. Obviously, methane is more manageable if you don't have billions of animals on your facility. So ultimately, the message here is that climate change is the ultimate problem, and methane is a big driver of that problem, and we have a win-win situation with addressing the problem is going to promote environmental protection, it's going to help animals. Factory farms are catastrophically bad for animals, for workers at those facilities, for the environment. And this all hands on deck idea is about changing that social culture about our expectations of what we tolerate and what we expect of others is going to help that political will percolate up to federal and state legislatures to make these efforts a reality. So just this last thought of inspiring all of those of you who are new to the movements to act. Greta Thunberg is my hero. And I think as a person and as a plaintiff, so she's just filed a lawsuit under the UN Convention on the Rights of the Child, and she's just single-handedly transformed a lot of the dialogue globally on climate change. There's all kinds of lawsuits that you've heard about from Jessica's presentation, the Juliana case, and many like them overseas. And then one person in Congress, a 29-year-old who almost single-handedly changed the dialogue about climate change in this stuck-in-the-mud status quo country we live in for the past 3 decades. All of that is, to me, this groundswell of change that's in the air, and it's a great time to continue to be bold and creative to make that into better realities in the future. Thank you.
Thank you for the excellent panel presentation here, and we're doing remarkably well on time. I think within the minute, everyone nailed their presentation. So we have, I believe, 20 minutes for questions, and we'll start over here on the left.
For Danny and Randall. Are chickens and either for meat raising or egg laying operations going to be brought into these regulations? I don't know what chicken farms, if they produce a lot of methane, but they certainly produce a lot of manure and a lot of torture. So will chickens be brought into this? Because no one ever seems to talk about them. It's always beef.
So in our NEPA lawsuit, we represent some community groups located in, actually, by community groups, I'm talking about Animal Legal Defense Fund. We have some of our members are in northeast and northern Arkansas, where they are living alongside water bodies that are contaminated by waste coming from chicken CAFOs, from
Okay.
both broilers and egg-laying hens. I think one of the main problems with regard to air emissions from chicken CAFOs is the ammonia emissions
okay.
from the litter, not necessarily the methane.
Right.
And there are some just absolutely enormous chicken CAFOs across the country. I think there's, for example, there's a defendant in another lawsuit, Hickman's Egg Ranch in Arizona, which is just, I think it's like millions of chickens in a series of CAFOs, and so you can see some pretty enormous emissions there.
Yeah. Okay, thank you.
Chris?
Hey, this question's for Randy. In the methane management you talked about there, is there a concern that if you incentivize these CAFOs to invest in that technology, that it then makes it less likely that they're going to switch away from animal agriculture and phase out meat and dairy, like you were saying?
Say the last part of the question again.
Well, you said there's this kind of series of goals, and one was methane management, and a couple down lower was getting farmers to phase out raising meat and dairy. But if you incentivize all these farmers to invest in all this biogas, like methane capture technology, then it makes it less likely that they're probably going to walk away from the animals because they've just put all this investment in. So I just wondered how you.
Yeah, that's a great concern. So we really need to find a way to do both. That we need to mobilize the baby steps to address the problem, but we ultimately have to keep those long-term objectives in mind, which is the transitioning away completely from the source of the problem. So carefully structuring those into law is a challenge, and I don't have the answer. I think you raise a great point that you kind of run the risk of choosing the baby steps at the expense of those longer-term objectives, and we don't want to do that. So I think. Well, I'd have to think harder about the best way to craft that in legislation, but that's absolutely something that makes this whole issue so challenging, whether we're talking about climate change generally or regulating factory farms. There's such an urgency to it, but politically it's such a difficult balance that you can't always approach urgency with end game now, because you could ultimately get nothing. And so I'm torn between this value of incrementalism versus the take no prisoners approach to addressing these issues, and there needs to be somewhere in between that we can achieve the something we need now with the path ahead for more built into that. And it's a general answer, but that's kind of how I'm thinking about it.
Cool. Okay, thanks.
Thanks.
Hey there, and sorry, this is a little bit repetitive to the question that Chris just asked, but I'd like to expand it to the whole panel. So this issue of biodigesters and the capture of biomethane. I'm just curious sort of where you three come down on that issue, if you see that as a viable solution, or as Chris alluded to, if that sort of entrenches a harmful industry, or just sort of your thoughts on that. And whether or not that's something that you encourage folks in this room to support in a general sense. Because as anybody on this issue knows, this is a huge area of movement right now, especially within hog confinement facilities and dairy industry. The taxpayer money going into subsidizing the installation of digesters and pipelines to move that gas around is huge right now. So just curious your thoughts on that. Thanks.
I mean, I think I can start. I have not thought about this issue a lot, but I do know from my experience working with landfills that the idea that you can capture and make profit from the sale of methane gas is largely a wishful thinking. It doesn't actually happen that often, and what really happens is it gets burned off. It's captured and burned off, and that's not any better. And then, generally, I know from an animal rights perspective, there is no benefit at all to animals or to people to housing animals in close confinement where they can't breathe fresh air because it's all being captured to be burned off or sold, allegedly. So I think that it's likely going to turn out, if I did not know that it was something that people are actually considering as an actual viable alternative, but should the government go that way and permit that type of activity, I think that we would find in 10 years it did nothing.
Yeah, I'll just add, thanks, that was really eloquent, that this is not going to be as eloquent, that digesters scare the poop out of me. I think, Tyler, you actually heard the same presentation that I heard, describing all of the horrors of digesters. So what we learned is that Smithfield in North Carolina is, I think, contracted with the state to test out these digesters, and there are thoughts about creating pipelines from digesters to certain communities to use as natural gas. So yeah, it's definitely in the works, and it's frightening. To sort of connect it to what I was talking about earlier today is just that there's a risk that this will be seen as agriculture that has been historically exempted from regulation. And so this industrial practice could, again, sort of fall within the tent of oh, it's just, farms being farms and not something that EPA should be regulating, whereas in every other context it would be highly regulated.
It's amazing to me we would think about doing that instead of just eating less meat.
Yeah, I think that's what Chris was going. It was angling towards.
Yeah.
Hello. This question is for everyone, actually. My name is Ksenia. I'm a 3L at UMass Law over in Boston area, but I actually grew up in the Midwest. And the Midwest has a lot of farms, and currently it's actually very flooded. So it's very interesting to see how, they really didn't think much about climate change until it actually happened to them. So we also talked a lot about remedies and elimination of subsidies and incentivizing farmers. And my question is how specifically do we go about that? We can talk about it and everything, but the farmers, when it's their actually livelihood, how can we get them to understand and what things we can do to kind of provide that support for it actually to happen?
I too am from the Midwest. I'm from Iowa, born and raised. Left in 2007 to be an environmental attorney in Missouri, so I didn't go far, and moved to California in 2013. So I've not been in California very long. And I think that the most effective way I think you can reach out to farmers and help them understand that a different path is possible, a different path is profitable, is to talk about the way it used to be. And I know that that's not exactly ideal from an animal rights perspective because it still required the confinement and consumption of animals. But at the very least, that opens a door with farming and the farming community to a discussion about a time when there wasn't integration, when there wasn't monocultures, when we didn't rely on the federal government to support every single aspect of farming, and that there was actual personal responsibility and reliance on communities in farming. And all of those things are values that the Midwest supports. And I think that, as you note, with climate change actually having impacts there, they're starting to realize it. And we're seeing some local farmers form community groups, join with national organizations, and actually try to do something about it. Is there a place for farming in the future that looks like it does now? The answer is no, and they've got to get on board.
Thank you. Do one last question on the right here.
Thank you. This is a question for all the panel. I was wondering if anyone has explored the option of filing a suit against the government to subsidize meat alternative production, from the food security perspective. Taking into account that animal ag is not going to be sustainable in the future, we have to ensure food security for all the population. So why aren't we subsidizing meat alternative development and research?
I'd be really interested to hear, more of your thoughts on this. I think suing the government to do something without a statute that requires it is always a challenge, but that may not mean that it's impossible. We're, like Randy was saying, that we're here for radical ideas, so I'd be interested to hear more about radical ideas. I think, the first thing that jumped into my head is that instead of litigation, I think, at these conferences and at other animal events, we often are trying to train each other in lobbying and having that be an important part of animal law practice. And I think that, as animal-friendly industries and and animal advocates become, larger and more powerful, I think that there's definitely going to be a role for that exact type of remedy, but maybe in a legislative context.
And I think that's what we started to see with that Colorado governor initiative, that it was looking for a win-win in the sense that promoting meatless production would be achieved through drawing on the state's farms to produce those meatless opportunities. So it's not this kind of the existing farms get obliterated if we're transitioning to meatless. There's a way of generating political will to get us there without this abject winners and losers right now. And I think that's ultimately what's going to be politically acceptable. The cultural changes will push that political will to get where you suggested we need to be, and I'm encouraged to see that's already starting to happen with efforts from political leaders. So that's encouraging.
Okay, thank you. That wraps up the panel. Liberty's going to be up in a moment for some concluding remarks, since this is the last panel of the conference. But before we transition to that, maybe join me in giving another round of applause to our panelists today.